Hi, welcome. I see some people are starting to join us. Thank you so much for being here today. For co-tenants, subtenants, and guests, rights of landlords and tenants. I'm Lisa from the Law Library, and with me is our speaker for today, Nick Cohenmeyer, who is a landlord-tenant attorney. And a couple of housekeeping things before I turn things over to Nick and have him get started. I wanted to start out by saying this is a community presentation today that we are not offering CLE credit for. No continuing legal education credit for this session today. However, Nick has committed to doing another session on this same topic in July with the specific date still to be determined, and we're going to offer CLE credit for that. And that one will be geared toward attorneys and legal professionals. So if you're looking for CLE credit, you can always come back in July and join us for that session. Keep an eye on our Law Library website, and we'll have that information shortly about what date that's going to be. This is also an interactive presentation, and Nick will be able to take some questions today. Hopefully there will be some time at the end for at least some of them. Just a little admonishment here. This is an educational program today. It's not meant for individual legal advice. So keep any questions that you're asking general and not too much detail about your own individual situation, as Nick can't give you individualized advice today. But general questions are welcome. And if you do have questions, feel free to use the Q&A function for that. You'll see on your screen Q&A with 2 speech bubbles. The chat is for panelists only, so please use Q&A for the questions. And you can also ask those anonymously if you wish. Finally, one more thing, you will see a link to a survey at the end of the presentation today. We would much appreciate if you take a couple of minutes to fill that out. It's very short. So with that, I'm going to go ahead and disappear and turn this over to Nick.
Thank you, Lisa. Good afternoon. Time is a little crunched today. We have a hard break, I believe, no later than 1:05, possibly 1 p.m. for the library. So I will try to get through this rather quickly and then have some time for Q&A at the end. So let's get right into it. My name is Nick Cohenmeyer. You didn't come here to learn about me. I don't think you need a long bio about myself. So let's just get right into it. What we're going to be talking about for landlords and tenants. I have a feeling most of you are probably tenants, but if you are a landlord, this would be important information to know. And if you're a tenant, this would also be important information if you're a landlord on. You know that your landlord is giving you full extent of the rights that you have under statutory common law, as well as other areas of the law that are gray. Let's get right into it with co-tenants, for example. Now, a co-tenant is defined as 2 or more tenants who rent the same property under the same lease or rental agreement. So this is usually like roommates, couples, and the key distinction for co-tenants over the other types of roommates or subtenants, guests, is that with a co-tenant, they are jointly and severally liable for the full amount of rent, as well as full compliance with the lease agreement or rental agreement. Now, during this presentation, I might refer to rental agreement. That includes, unless I say otherwise, leases and month-to-month rental agreements. So with a co-tenant, they generally are signing the lease at the same time. And you'll see why that's important later when I talk about guests and occupants. So why would someone want to have a shared tenancy? Well, common reasons would be that marriage, romantic cohabitation, or simply because the rent would be too expensive to afford on their own. So you have college roommates, you have friends that want to live together. These are generally co-tenants so long as they sign the lease at the same time. So what I wanted to say is that with co-tenancies, do not get involved if you're the landlord in a dispute. And if there are exceptions, which there are, I'll talk about that in a moment. But this is one of the reasons why landlords might not want to allow co-tenancies. It's just extra hassle when they could have another tenant, another applicant with just one person on the lease. It's less wear and tear on the unit. It's less consumption of utilities. But just like more things in the law, especially California law pertaining to residential tenancies, there are always exceptions, and you can't just say no to co-tenancies as a blanket rule. So again, if you're a landlord or if you're a tenant and you think your landlord may not fully understand his or her obligations under the law, this is why you would want to pay attention to this presentation. So screening co-tenants. So when the landlord is screening a co-tenant, and again, this is two tenants, two or more tenants that are applying for the lease or rental at the same time, then the same general rules that apply to any applicant would be applicable to screening co-tenants. So the property owner should require any applicant 18 years old or older to complete a full rental application. This would be just the same as any applicant would if they came along to sign the application. And you should use no more and no less of the screening criteria for the co-tenant. So this is where landlords can quickly find themselves in trouble if they're not using consistent screening criteria. One of the most important lessons that landlords need to learn before they learn it the hard way is that if you have certain arbitrary rules because you just kind of are flexible, what a lot of landlords are, they want to be friends with their tenants, so they let certain things go, they let certain things slide. That's probably fine until it's not. And when it's not, then you face yourself with a discrimination lawsuit potentially. The reason is you have to treat every applicant the same, regardless of what their race is, what their religion is, even marital status in California. So there's federal protected classes. California takes those protected classes and extends them even broader in favor of the employee, the tenant, etc. So if you treat non-married couples differently, you're going to find yourself in trouble. One area where this tends to happen is co-tenants try to pool their income together to qualify for minimum income threshold qualifications. Now, if you allow married couples to do that, you have to allow unmarried couples to do that as well. Again, just you need to be treating all applicants the same. So who should be named in the lease agreement? Well, every person that resides in the unit should be named in the rental lease agreement, and minors generally don't. And if you have disabled residents that are applying to be co-tenants, well, they probably don't need to be part of the contract. If they're severely disabled, they can't legally contract anyway. But if you're a landlord, the more people that sign your lease that understand and agree to your terms, the better for you. And one area where you might also have co-tenants, and I'll talk about that in a minute, is disabled residents. So you might have disabled residents who need a caretaker, and maybe they sign the lease at the same time. They also might come on board as another occupant, long-term guest. And I'll talk about that in a moment as well. Just understand that if you're a landlord, if you can get the occupants to sign the lease at the same time, then you have a co-tenancy, and that is ideal because if one tenant doesn't pay the full amount of the rent, then you need to just serve both of them with a 3-day notice to pay a quit. It doesn't matter that of John and Sue, your two tenants, that John paid his half, but Sue didn't pay hers. That's going back to roommate conflicts that you do not need to be part of. Similar with security deposits. What often happens with co-tenants is that one of the co-tenants moves out. And this could happen because the school semester is out, where you're renting to students, or there was a divorce, a separation, they were dating. Whatever the reason, oftentimes a co-tenant who moves out wants their security deposit back. So you have to give it to them. And the answer normally, there's always exceptions, but normally is that you do not, as a landlord, have to give them back their partial or prorated deposit. The purpose of the security deposit in California is to restore the unit to the condition it was in prior to the move-in, other than wear and tear and a few other exceptions. So you don't have to return the deposit until both co-tenants are out, until all co-tenants are out. Now you can encourage the co-tenants to have an agreement among themselves. I'll talk about roommate agreements in 2 slides, but again, don't get involved in roommate disagreements, okay? So benefits of roommate agreements. Well, there are many, and how do you make one? Well, one way is to go online, find a template. Other times you want to just have your own roommate agreement template ready that you can give anytime you have two co-tenants, so it's ready to go. And then it doesn't involve you. You're just giving them a blank template to fill out between themselves or among themselves if there's multiple, such as with students. And that lays out who's responsible for certain chores that they both understand they are to pay the full amount of rent each month, things like that, that they can work out among themselves. But again, just like with roommate disagreements, if there's a breach in the roommate agreement, you do not have to get involved. But when it does become your responsibility is when there is domestic violence. So California recently passed a law that says if you're a victim of domestic violence, you are allowed to break your rental agreement or even your lease within a 14-day notice period. After that, you are cut off from any future obligations to the tenancy. You don't have to pay rent after that if you can show that you are a victim of domestic violence. Now, that's another presentation to go into details of what you need to show for that, but several of the things that are necessary are some kind of proof. So one of them could be a proof of restraining order. That's not the only way to show it, but that's just one example. You can't just arbitrarily say, he threatened me, I need to leave. There has to be an additional step that provides some substantiation. And lastly, does a landlord have to allow co-tenants? Normally, no, but when it comes to things like disabled tenants, where one tenant is physically disabled, they're mentally in full capacity, they can still contract, but they want to have someone there as a caretaker. You can't deny that. And there are a few other exceptions. If they have, if it's an adult who wants to bring in an adult child who's disabled, who's a dependent, that would be allowed. You can't deny that as a landlord unless there has already been an instance of disturbance on your property with the two parties involved. So if you want to add basically, if you are changing co-tenants, then you can use a change in occupancy form. There are multiple reasons to use a change in occupancy form, such as you're bringing on a guest at a later date. But ideally, instead of a change in occupancy form, you would just have both parties sign a new lease agreement. So if you're on a renewing annual lease, some landlords use renewing annual leases that at the expiration of the first lease term after 1 year, it renews automatically. Instead of renewal, just give them a new lease. Otherwise, if you're on a 30-day month-to-month rental, just have them sign a new rental agreement at the same time. It's just easier than doing a change in occupancy form. I don't want to get too much in the weeds right now because I believe that the majority of the audience are tenants, but just so you know, your rights as a landlord, and especially your rights as tenants, if any of this applies to you. And what happens to the remaining tenants when one co-tenant vacates? Well, the remaining tenants are still liable for the full amount of rent. And again, you're not entitled to get back any security deposit from the landlord, but they can work among themselves. Now, what about if a landlord wants to do like a partial eviction? Well, normally, that's not allowed. Normally, it's not encouraged. Sometimes it's allowed. It depends on the jurisdiction. It depends because when both co-tenants sign the lease, they're basically there together. They're jointly severally liable. But one example where you could do a partial eviction is, again, where the 14-day notice of intent to vacate has been provided. And this is the form. It's just a sample form. Don't use this one exactly. But if you're curious in the law of what requirements there are, look at California Civil Code section 1946.7. And that lays out what the requirements are for a tenant who's been a victim of domestic violence to request that they leave the rental or lease agreement with 14 days for obvious reasons. It also is one of the areas where a landlord is allowed to change the locks without a court order. Otherwise, the landlord is almost never allowed to just change the locks arbitrarily, and the landlord can find themselves in big trouble to do that. So if your tenant, your landlord, has tried to use what's called self-help eviction to get you out, by cutting off the utilities, changing the locks. Call an attorney immediately. Ideally, one who specializes in this type of law, but if all you have is any attorney, they will probably know how to educate themselves on this area of law. Now, there's a few other drawbacks for using separate agreements for co-tenants. I'm gonna have to skip over a few of these slides because we are running out of time. I want to make sure there's plenty of time for Q&A. Now, if anybody wants me to discuss these things, let me know at the end. But so let me jump into overnight guests now. So when I talk about guest restrictions, it's going to be referring to overnight guests. Obviously, if you want guests there every day, that's fine to an extent, as long as it's not causing a disturbance. But the main purpose when I talk about guests is overnight guests, and that's where it gets a little problematic because there should be a restriction in your lease if you're a landlord that limits the number of both consecutive days that an overnight guest can reside at your property, as well as total number of days that the guest can reside at your property. Now, why would a landlord want to reduce the number of days or eliminate them altogether? Well, I'll talk about that in a minute, but it obviously increases the consumption of utilities as well as wear and tear. So I strongly urge all of my landlord clients to clearly specify in their lease how many days a guest may reside in a monthly unit. And there's a few other things that I strongly urge them to consider as well. We'll talk about that in a minute. So how many days is a reasonable maximum overnight for a reasonable maximum number of days for overnight guests? Well, as you see here, the significance of this mobile home park is that California doesn't specify for residential tenancies any specific number of days that a landlord must allow for overnight guests. But if you do have a mobile home, which obviously is not within the scope of this presentation, that's a whole nother presentation I gave on the MRL, the mobile home residency law. That is how mobile home parks are generally governed in California. That one does provide some guidelines. If you're wondering what might be reasonable because there's no clear common or statutory law on this, the mobile home residency law, the MRL, permits guests for up to 20 days consecutively or up to 30 days in a calendar year without having to get permission, usually from the mobile home park, the management. Now, anything beyond that would require an agreement. So if you find in your lease that it's restricting it to 20 days consecutively and no more than 30 days per calendar year, that should be reasonable. Obviously, every case is different, but there should be something more than nothing when it comes to the number of days you are allowed to have overnight guests. And when can a landlord say no to overnight guests? Well, generally, the landlord cannot exclude overnight guests unless they've been a problem in the past or they've overstayed, the number of days. Now, one area where the landlord absolutely cannot restrict overnight guests is when the overnight guest is in a category that's protected under state law. And state law, when it comes to areas of protected classes, is almost always broader than federal law. We'll take a pause and get this up. So that means things that a landlord could restrict in the federal law, the landlord cannot restrict if this is a California landlord, California property. And one thing that California protects where federal law generally doesn't is married and unmarried couples. So you have to provide the same rights and protections to unmarried couples as you do for married. Now, one more thing where a landlord has to be very careful with is that if a guest ever claims that he or she is a tenant organizer or is there to provide tenants with information about their rights under California law, then a landlord absolutely must not restrict these types of guests. This would be similar to union organizers in business context. Now, both union organizers and tenant organizers have rights and protections, and they are legally allowed to be there. And a landlord could face serious penalties for interfering with the right to help others understand their rights. Now, one of the exceptions would be where the tenant organizer is citing a disturbance or some kind of aggressive action that's interfering with the other guests' right to quiet enjoyment on the property. Now, if that's the case, then the landlord could, and in fact, probably should, correct the disturbing behavior because, again, as I mentioned at the beginning of this presentation, it's a landlord's obligation to provide quiet enjoyment for the tenants that reside on that property. So I understand how this can get tricky, right? We have the rule and then the exception of the rule and then the exception to the exception, right? So this is an overview of topics that you might want to learn more about. I am happy to provide these presentations. Obviously, I can't give follow-up free pro bono advice to everybody, but I am a licensed attorney, and if you're looking to hire me, then get in touch with Lisa, and she will have you get in touch with me. Okay, so Lisa is the San Diego Law Librarian who you saw at the beginning of this presentation. So a couple more things with overnight guests. That it's important to remember that the rules that a landlord has usually have to be in writing. It's really difficult, sometimes impossible legally, to enforce rules that are not written when it comes to landlord-tenant law. So this is one of the reasons why standards for guests should be unequivocally spelled out in the lease or rental agreement. Now, in addition to having clear rules in place, a landlord should also have systems in place to monitor and track the length of the stay by the overnight guest in the landlord's property. It's like, how else would a landlord know if there's a guest there, specifically when the guest first started staying over, so you can start that clock. So if you have a 20-day cap in your lease, you know, I started seeing this car around Tuesday and it's been here every night. So, you know, there's obviously other ways that the guest could be there without you knowing, but you have to put forth a reasonable effort. And one thing that landlords can do, this is kind of a dirty trick, I guess. So if you're a tenant, it might be helpful to you, is that landlords can get around the prohibition from doing just general maintenance inspections. You can't just have a general inspection to get access to the unit. It has to be something specific. And one area that landlords typically use is smoke detectors. So they want to do a smoke detector test. So they give you 24 hours notice. But what they're really there to do is see, okay, are they growing pot, you know, using grow lamps? Are they running, you know, blockchain mining equipment using my electricity? And do they have any unauthorized occupants? Like, wow, this guest bed is being slept in. I wonder who's sleeping here. And that's where it gets tricky, because just because you see it during that inspection, it's still going to be a tricky conversation to have to work within what you're allowed to say as a lawyer. I'm sorry, as a landlord, also as a lawyer, if you're getting legal help, to investigate, you know, why is your bed not being used, or why is your bedroom and your couch being used, and I see, you know, stuff all over the place. You also have to inspect as a landlord to make sure that there's not waste being committed on the property, that it's not a fire hazard, because sometimes you have tenants who are there for 20 years or more, and these apartments generally are pretty small in San Diego. So after 20 years, you have a lot of prized possessions, a lot of keepsakes, totally understandable. You can't get rid of everything, and everything, you know, has some kind of sentimental value, but you just don't have room, and it just starts piling up. So a landlord needs to check that this is not becoming a problem. That's why they use either legitimate reasons to enter the premises or maybe ulterior motives. But that's going back to how a landlord could find out whether there is overnight guests that are staying beyond their contractual maximum. So when a tenant wants to have a long-term guest, you should consider giving a long-term guest addendum. And what this does is it says the name of the guest may temporarily occupy the premises, and you have some kind of ID that the landlord or apartment manager has checked. And then it clearly spells out what the tenant is allowed to use in terms of like common areas, the pool, as well as reminding the guest and protecting the landlord by putting this in writing that the guest is not a tenant, does not have any right to possession, and the resident is responsible for the guest and the guest behavior. And it makes it very clear that this is a guest, not a new tenant, not an implied tenancy. So how many landlords do this? Not many, especially not the small ones. The multifamily probably do, but the small ones probably don't. And that's where they, as I like to say, they learn the law as a defendant, and that's not what you want to do. That's one of my silly slogans for my law firm: don't learn the law as a defendant. That's why I work with both sides to figure out in advance what their legal rights are, so they don't learn the hard way as a defendant by learning the law from the judge. Now, overstays. So when a landlord becomes aware that an overnight guest is about to or has already started to stay longer than the contractual maximum number of days under the lease or rental agreement, then the landlord should treat the overstaying guest essentially as an applicant to rent, and then provide that overstaying guest with an application to rent. So a landlord should make sure to provide all the written disclosures that are normally required whenever a normal applicant applies to the property, such as if you're doing a credit check, you need to provide the proper credit check disclosures. And if you did the credit check and adverse information was found that would deny the tenancy to this applicant, then the landlord needs to include those forms as well, such as a notice of denial to rent, which makes it clear that the denial of rent was based on adverse information that was found during the credit report. Talking a lot, and I'm running out of voice. So if the overstaying guest, which now has turned into an applicant, does not meet the same standards, again, same objective standards, don't have different standards for these types of applicants versus just a normal applicant to a vacant unit, because you're trying to keep out this overstaying guest, you're going to probably find out pretty hard as a landlord that you can't do that without legitimate reason to. But I'll talk about it in a moment why a landlord would want to restrict additional applicants to the same unit. But for now, what I'm talking about with the overstaying guest turning rental applicant, they have to meet the same objective standards that any other applicant would be expected to meet. And then if they don't, then that applicant is basically no longer an applicant and they're no longer an overnight guest. And the landlord's next option would be to serve that tenant. I'm not talking about the guest, I'm talking about the original tenant, with a 3-day notice to perform or quit. And as you'll see an example of that on the screen, it's a 3-day notice to perform conditions in our covenants or quit. Now, why is it this notice? Because by having an overnight guest who has stayed beyond the maximum number of nights that you, as a landlord, have allowed your tenants to have in their lease or rental agreements, then that tenant is now in breach. I'm about to sneeze. Pardon me. So if that tenant is allowing their guest to stay longer than the 20-day or 30-day maximum that you have in your lease rental agreement, then you, as a landlord, can serve them with a 3-day notice to perform conditions or covenants or quit. What this notice is saying is that you are in breach, and you have to specifically describe the breach, and you also have to specifically describe where in that lease or rental agreement the provision is that your tenant is violating, which goes back to why I said you have to have rules in writing if you want to enforce them. So once you find out that there's a guest, find out that the guest has stayed beyond the maximum, given that guest an application for rent, and then D, figured out that the guest does not meet the same objective criteria that any other applicant of the property would meet, then E, we are on the stage where we serve the tenant with the 3-day notice to perform or quit, which means you have to get rid of this overnight guest, or you yourself, the tenant, will be evicted through an unlawful detainer because you are in breach because of this clause in my lease for this reason on these dates. And this is a curable breach in most cases. Sometimes it might not be, but in this case, it should be considered a curable breach, which means just like having an unauthorized pet, if you get served with a 3-day notice to perform covenants or quit, that just means you have to get rid of that pet within 3 days. Otherwise, you are forfeiting possession of the premises and you shall be evicted through a court order. But again, if a landlord ever tells you, hey, you got to leave, and he doesn't have the sheriff with him, and he doesn't also, and I say he, I'm saying he or she, and then your landlord, he or she doesn't have a writ of possession from court, be very skeptical when you start seeing your stuff get thrown out. And again, call a lawyer, because if a landlord is trying to use self-help, it's probably illegal, and it's probably going to be an illegal lockout where it's not just that the landlord can't do it, the landlord will get punished for doing it. There's financial penalties. So there are many areas of landlord-tenant law that I could discuss. I've discussed a few with the San Diego Law Library. I have a few more on my website. But there's so many intricate areas that it's really important for me to go deep into those singular subjects. Right now, I'm giving you kind of a high-level overview, even though it's narrowly tailored to just the topics of guests and subtenants and co-tenants. There's still so many different areas and other unexpected areas that pop up when we're having these inquiries. So, is a landlord obligated to offer a tenancy to a guest? Well, it depends why a landlord is rejecting that occupancy. So now one of the reasons why a landlord might not want to offer the tenancy is that additional occupants in a unit will most likely increase wear and tear and consumption of water, electricity, and gas, which should only really be an issue if these are not sub-metered and the landlord is paying for them his or herself. But another reason might be that some landlords won't or cannot increase the rent when additional guests are moved in. So the landlord would essentially be having to bear increased expenses without increased revenue to compensate. So when is a landlord obligated to accept an overstaying guest as an additional tenant, and when can a landlord refuse? Well, this depends on the type of guest. So if the overstaying guest is an immediate family member or caretaker, the landlord probably does need to offer them a tenancy. And any other type of guest is probably not entitled to the offer of a tenancy. But before a landlord makes that determination, or if you are a tenant who thinks the landlord made an improper denial, it would be wise to consult with an attorney with competence in this area to ensure that a local ordinance doesn't change this presumption. Now, one thing that landlords often try to do when they have additional occupants, especially ones that they're required to allow, is to charge a guest fee. And why would they want to charge a guest fee? What is a guest fee? Well, it's an additional source of revenue to offset the added wear and tear and consumption of additional utilities that will presumably be caused by the additional occupants. So it seems reasonable that a landlord should be entitled to offset the landlord's costs by charging a guest fee to the tenant. But here are some of the potential problems to consider before a landlord charges these fees. First, a landlord who charges guest fees, especially for guests that stay beyond the contractual maximum, might be considered to have waived the right to enforce the contractual maximum by accepting the guest fees and thus the guest. Now, this could potentially even change the guest status from guest to tenant. And this could make an eviction more difficult, since the landlord would now be on notice that there are additional occupants in the premises and we need to identify them either specifically by name or as John or Jane Doe unnamed defendants, because you don't know the specific names of them. And next, charging a guest fee might be found to be part of the rolling 12-month gross rental rate. In other words, it might increase what you are now charging for rent. And that's important because of what's called AB 1482. Now, AB 1482 took effect in 2020, and it added restrictions on how much and how often a landlord can increase the rent over a rolling 12-month period. Now, typically, this rent cap is 5% plus the change in CPI, never to exceed 10%, but some local ordinances restrict this amount further. So if you're going to charge guest fees, and I'm not necessarily suggesting you should or can as a landlord, make sure the amount you charge can be reasonably substantiated based on actual costs for increased utility consumption and depreciation, especially of carpets and other things that are wearing much faster because of the additional load on them, and not due to your own arbitrary and subjective estimations. So at the time of this presentation, June 23rd, 2022, June 23rd, 2023, excuse me, at the time of this presentation, neither statutory nor common law is clear on when and how much a landlord can charge for a guest fee. But one strategy I've seen some landlords use is to calculate the difference in baseline usage from before that occupant came aboard to after, and figure out a reasonable increase, and then charge that increase to the tenant. Now, that's not necessarily always going to work in court, but it's usually going to work better than when the landlord just makes up a random figure and then charges the guest fee, especially when everything is sub-metered in terms of the utilities for the gas, for the water, for everything else, electricity. If the landlord can't show a quantifiable increase in expenses, the landlord is probably going to have a tough time recouping the expenses as a guest fee, and it probably struck down as valid. So that's why I feel this presentation is useful for both landlords and tenants. I hope the tenants here, the audience members who are tenants, are probably thinking of a couple things that maybe you're scratching your chin and wondering, is my landlord actually complying? Is my landlord in violation of these principles? Now, I help both sides. I'm not gonna do another pitch for my services, but I help landlords and tenants, and I understand that it's not easy to be a landlord in California, and not all landlords, especially single family, mom and pop landlords, are just raking in the money. Keep in mind that ever since AB 1482 was passed, and if your property is subject to AB 1482, not exempt, then essentially a landlord's profits are capped. They can't charge more than the rent that they've been charging with an increase of 5% plus CPI. So that's the cap on their revenue, but everything else is increasing. Insurance, supplies, water if they still provide it, contractors for making repairs. So, have a heart for your landlord if you can. I certainly have sympathy for the plight that a lot of tenants are in when they have unscrupulous landlords, but just remember that, neither side is always at fault. Neither side is never at fault. So what are some of the differences between occupants and guests? Now, before I get into that, it should be pretty clear what a tenant is, because a tenant is normally a signatory to the lease. But what gets more complicated is who is an occupant and who is a guest. So if a non-tenant occupant is only temporarily occupying the unit, then he or she is a guest, like we talked about, overnight guest. Now, it normally is not appropriate to name guests in the rental lease agreement because they're just there sporadically, intermittently. But occupants are typically named in the lease rental agreement, but they don't necessarily have to sign. So the tenant obviously has to sign, but the occupant may not have to. And one example is with minor children, because minor children cannot contract, they're minors. Same with individuals who are mentally disabled, incapacitated. They don't have the wherewithal to understand what they are agreeing to. Therefore, when they sign a contract, it can't be enforced against them because they are not parties that have the capacity to contract. And if you have well, let me talk about occupants with disabilities. Now, this is a category of occupant where, for example, a person over the age of 18 is permanently occupying the unit to care for the tenant. Now, you could have a lawful occupant, but not a tenant, where a disabled adult lives with the tenant and is caring, or a disabled adult lives with the tenant and is, being cared for by the tenant. So it can go both ways. You can have a disabled adult who is being cared for by the tenant. You can have a tenant who is giving or who's getting help, a disabled tenant adult who's getting help from a care provider. Either of those would be instances where you have lawful occupants. And if you, or the landlord, are denying disabled individuals or their caretakers the right to become an occupant, then you're probably denying them what's called a reasonable accommodation. And if you deny a reasonable accommodation or a reasonable accommodation request, then you as a landlord can find yourself in expensive legal trouble if the denial is given without going through an interactive process with the individual requesting a reasonable accommodation. Now, another area where this needs to be done is when a tenant requests a service dog. You cannot just say, we don't allow dogs, we have a blanket rule, you know, there's an allergy with a occupant next to you. You can't just have blanket rules when these are reasonable accommodation requests pursuant to a recognized disability. So even if you think that this is impossible for me to grant, you have to go through an interactive process where you can determine if there's a way to make this work as a landlord. If you don't, you're going to find out the hard way that you made a mistake. Now, when a disabled adult lives with the tenant, that's one of the areas where I talked about where he or she could be designated as an occupant, and that could be the reasonable accommodation. So, subleasing, and we are almost done, so I'll have some time for Q&A, and I think we can have a hard cutoff at 1 p.m. So it's 44 minutes in right now. So what is a subtenant? What is a sublease? Well, I'm sure most of you have heard of subleases, and they're pretty straightforward, but where it gets tricky is what happens when the subtenant is a problem, who can evict. So let me first talk about the sublease arrangement. Now, just real high level, in case you haven't heard of subleasing or you need a refresher, a sublease or subtenancy is an agreement in which a tenant rents all or part of the lease premises to a subtenant. Now, in this chart, we have the landlord, that's obvious, the tenant, which normally it's just here, landlord-tenant. But in a sublease, this tenant is still the tenant of the landlord, but now the master tenant to the subtenant. Now, the master tenant normally does not relinquish control over and will plan to retake possession at a later date. So they might have, moved out, they might stay there, but they're just bringing someone else in. Not to be confused with an assignment, that's something different. I'll talk about that in a sec. But in a normal tenancy, the original tenant, also known as a master tenant in a sublease, has the landlord-tenant relationship with the property owner. But in a subtenancy, the master tenant, which is the tenant here, now becomes the landlord to the subtenant. And that's where it gets a little sticky and tricky when you have a landlord who wants to evict the subtenant, where the landlord never actually entered into a contract with the subtenant. So can a landlord deny subleasing? Well, normally the landlord can, and most of the lease agreements I use that are not in rent controlled jurisdictions prohibit subleasing. But in the absence of a prohibition against subleasing an assignment in a rental lease agreement, subletting or assigning the right of possession by a tenant is generally allowed in California. So, is a subtenant also a co-tenant? No, because a co-tenant exists when two or more tenants rent the same property under the same contract with the landlord. They're both in what's called legal privity with the landlord. Where a subtenancy exists is generally after the tenant has come on board, now they bring in somebody else. After that tenant had already signed a lease with the landlord, now they sign a new subtenant lease with their subtenant. And now if you're watching this as a tenant and you're thinking about doing a sublease, well, now you can be watching this presentation as a landlord, because if you're going to bring in a subtenant, well, first I recommend that you have permission from the landlord, not just in the lease where it's not unauthorized, but you also have permission. Even if the lease doesn't prohibit it, you're better off getting express permission, not, oh, hey, Jane, is it cool if I bring in my friend Tom to, live with me for 6 months and he'll be my tenant? Oh yeah, that's fine. No, don't do it verbally. Do it through ideally a written agreement, which you should definitely have with your subtenant, which you have here. But prior to that, get a written agreement, a written acceptance from the landlord that you're bringing in a subtenant. And maybe the landlord, wants to charge a little extra for that. if they're not prohibited from doing so, make it worth the landlord's interest, because now there's new complications that are arising with no real benefit to the landlord. So if nothing else, send an email or text. If you can't do anything better, that's still better than verbal approval of your subtenancy. You don't want to find out after you've moved your tenant in and all the tenant's things and the tenant is settled in and assume that you know what you were doing, that you don't, and that you're not allowed to have a subtenant. It's going to be embarrassing and tricky, and you could face eviction yourself. So it's generally not in the owner's interest to allow subletting, because it does take away control from the owner in terms of deciding, who can reside in the rental unit, which still belongs legally to the landlord, even though possession may still be with the master tenant. So the landlord doesn't have contractual relationship with subtenants. That's why it's important to be very careful of, if you are going to let in a subtenant, that you at least do yourself the background check, or if it's a subtenant, more likely your master tenant, your tenant will do all the background checks, but you can give them the same criteria that you expect of all tenants yourself. So, you shouldn't allow subtenant to, maybe have like 6 pets when no pets are allowed, notwithstanding service dogs, because that's going to create discord on the property. Now, as a landlord, you can be less concerned that your subtenant, not your subtenant, but that the subtenant is paying rent on time, because it doesn't make any difference to you. You are getting paid from your tenant. I go back a slide. Remember, the only person that's paying you is your tenant. So if the subtenant defaults, you don't have to entertain the excuses from your tenant that, hey, my subtenant didn't pay me this month, I can't pay you the rent. That's not your problem. That's your tenant's problem to deal with their subtenant. So you see where this gets, sticky and tricky, where you want, as a landlord, to try to just avoid subtenancies if you can. In general, it's up to you, but oftentimes there are more problems than they're worth. So an alternative to subleasing is to just have the tenant apply to be a co-tenant, maybe start a new lease over with both of them on the lease. That's the cleanest. And I do have to rush through companies' assignments. So in contrast to subleasing or co-tenancies or guests, an assignment is when the original tenant agrees to transfer all of his or her legal interest in a lease to another person. Now, the old tenant would be the assignor, and the new tenant is the assignee. So they assign the lease to a new tenant. And that is different from a subtenancy, because in a subtenancy, the master tenant plans to reoccupy the unit, regain possession. In an assignment, that assignor is done. They are just giving away their tenancy to somebody else. And the person to whom the lease is transferred to, the assignee, steps into the shoes, it's a legal term we like to use, of the original tenant, the assignor, and becomes a new tenant of the premises with a direct landlord-tenant relationship to the owner. Now, why would landlords be against this? Well, because it's not just because they want to be a pain in your, it's because landlords might not have control over who is being assigned. In other words, their strict criteria over who they allow in their units might be completely ignored when you have a tenant who is assigning their lease interest to somebody else without your knowledge or consent. So you don't want to allow assignments. That's why you should have a prohibition, if you want, in your lease, prohibiting assignments and subleasing, notwithstanding, landlord's express permission. And I think I can skip over a few of these because we want to get into Q&A. But we talked about the rental payments, we talked about security deposits for co-tenants, and the other issue with security deposits is, when you have a new tenant come in, who gets their security deposit paid. Now, that is nothing that the landlord has to be part of. That is an agreement that, let me rephrase this. So if they are co-tenants, if one person is moving out with a consent and knowledge of the landlord, and that person gave the security deposit directly to the landlord, then perhaps the landlord can agree to refund the security deposit to that tenant that is moving out and then accept the new security deposit from the one that's coming in. But what often happens is that there's a remaining tenant that it's a co-tenancy because there's an intimate relationship and one of the spouses is moving out. You're generally not obligated to split the security deposit. The security deposit should remain intact, and then the person who's moving out can negotiate with the person who's moving in to transfer the security deposit to them. And if it becomes problematic, because if the tenants can't agree to resolve the dispute among themselves, then the tenant seeking to recover his or her share of the security deposit may have to bring an action in small claims court against the co-tenants to recover their share of the deposit. So we also talked about unauthorized occupants, and that is, where the tenant allowed somebody to move in without the landlord's knowledge or consent. If there's a prohibition on subtenants, that would be an unauthorized occupant. If there's a prohibition against assignment, that would be an unauthorized occupant. If the guest has overstayed their top, that again is not codified in statutory law or case law, it should be codified in the contractual agreement that the party signed, then that would be considered an unauthorized occupant. And depending on the type of occupant, you probably will have to evict the tenant along with all the other unnamed and unauthorized occupants themselves. So when the landlord discovers that there are unauthorized occupants, the landlord should first determine whether the tenant who improperly moved in the unauthorized occupant is now in breach of the lease or rental agreement. So read your rental agreement. You can't enforce rules that aren't written usually. And then while this could be an incurable violation that warrants a 3-day notice to quit, I recommend that you give, if you're a landlord or that you're a tenant, you receive from the landlord a 3-day notice to perform covenants or quit. If you just got a 3-day notice to quit, talk to a lawyer. The landlord might be jumping the gun, because if it's something that's curable, like getting rid of the occupant and all of the things within 3 days and restoring the premises to the condition it was in before, then you probably could be in compliance, and the landlord will probably be found to have acted in bad faith if they just served you with a 3-day notice to quit. Technically, they might be within their legal rights to do it, but when it gets adjudicated by a judge, it's going to be more contextual than, look, it says, no co-tenants allowed, or no subleasing, no guests after 20 days. They had a guest at 21 days. I served them 3-day notice to quit. It should at least be a 3-day notice to cure the violation. So in other words, perform conditions and or covenants or quit. And then only then, if your tenant is not willing to comply or cannot comply within the 3-day waiting period, then the landlord can commence what's called an unlawful detainer, which is the eviction process in California. And if the landlord prevails at trial, in which the question of lawful possession is being adjudicated, then both the offending tenant and the unauthorized occupant could be removed from the premises, forcibly by necessary, but by who? Not the landlord, by the sheriff. Remember that landlords and tenants should always check local ordinances before acting, as they might restrict landlord and boost tenants' capabilities. That concludes today's presentation. I will stick around for Q&A. My name is Nick Cohenmeyer, and if you found this presentation helpful, please definitely let the San Diego Law Library know. I will keep making these presentations if people are finding them helpful. And if you want to help me help you, then give us some ideas for presentation topics, things that you struggle with, that you're unclear on, that you think your landlord might be violating. And of course, if you're a landlord, let me know what presentations you would find helpful. It's very, very tricky to be a landlord in California. If you don't think it's difficult, then you probably don't even know what you don't know. Okay, that concludes today's presentation. Let's get into the Q&A for as much time as Lisa can allow.
All right, I'm going to help out by reading some of these questions, and we'll try to get through a few of them. If one co-tenant moves out and this person posting wants to add a new co-tenant who meets the same financial requirements, can the landlord say no to renting to a new roommate?
Okay, good. Let's see, what time was that question mark, so I can read it?
12:27.
Okay, So if we're gonna, what I mean. So if this is an excellent question, and if the landlord is saying no, whereas there's nothing on paper that the landlord can cite to that makes that new co-tenant capable of qualifying, then that is presumably the landlord acting in bad faith. And since you already have a co-tenant to begin with, it's not that the landlord is going to be necessarily worse off by having a co-tenant. This is an area where landlords have to be very careful that they are applying the same screening criteria to all applicants, regardless. Now, if the landlord says, well, same financial requirements, they met the same FICO score requirement, but this didn't match up because the tenancy history wasn't sufficient. Keep in mind, no two applicants are always the same. If the landlord is, somewhat sophisticated, the landlord's probably going to find some other, kernel in that applicant's file, some other grain of truth that is buried in there and say, aha, this is why I'm not renting to this co-tenant because of this different criteria.
So another question, if one roommate wants to give a notice to vacate, can the other roommate stay in the house / rental?
Okay, good question. So if one roommate wants to basically get out, yeah, the other roommate can stay so long as the other roommate takes over the full lease. They're going to have to pay the full amount of rent. If one roommate has been paying $500 of the $1,000 monthly rent, which I know no longer exists on the EU, but if that roommate is paying $500 and leaves, the remaining roommate is now going to have to pay $1,000 until they find a new roommate. But it's not the landlord's problem necessarily to go find another roommate. And I'm not talking about the exception of domestic violence under the civil code of that. This is just in general what is generally applicable.
So one quick question for you. We had someone who posted, what's a subtenant? Can you go over that real quickly again, the definition?
Absolutely. So a subtenant is when your tenant brings in their own tenant. So normally the tenant is a tenant of the landlord, but the tenant can become the landlord to the subtenant if, let's say, I'm renting my unit from Lisa. Lisa's my landlord, and I want to bring in someone who pays me a monthly rent, and therefore it helps me pay Lisa my monthly rent. I would still be Lisa's tenant, but now I'm considered the master tenant for my new friend John, who is living with me, renting a space on the couch that I'm renting. That is where you have a subtenancy. And where this is starting to really become problematic is with short-term rentals, with Airbnb. That is a whole other area of law that is very, very unclear right now, where you have tenants that are renting out their rented places. So on those short-term rentals, is that considered a subtenant? Is that considered a lodger? Is that considered something else under short-term rental laws? So I think your audience's question was specifically on the conventional notion of what is a subtenant. A subtenant rents from the tenant, and that creates a sublease.
So I'm going to just read one more question. We're not going to be able to get to all of them, unfortunately, because of time today. When a landlord rents out bedrooms in a house to different people and they all have different leases, and landlord does not live in the house, what is that arrangement called? Is it a boarding house? And is it covered by different laws?
Oh, that one really depends. That's a really good question, because that depends on how it's structured. Because I'd have to. That's one of the areas where I'd have to look at the specific context. I'd have to look at the lease, and to tell you that certain traditional laws apply and certain ones don't. Because that might even be an unauthorized tenancy. That might be the landlord violating some codes if they're not careful. So before I even tell you what type of tenancy that is and whether laws apply, you first have to see, is this house even permitted to have this type of occupancy load? And does it have all of the fixtures that would make this statutorily habitable? Because if they're renting out rooms, and it doesn't provide dedicated facilities for certain categories, that can be problematic. So I'm not, that's all I can say right now without looking at the details of that arrangement.
So I'm going to read one more, Nick, if you don't mind. If there's multiple tenants, when returning a security deposit, does the landlord make out a check to one tenant, to all of them in equal amounts? How does that work?
So if there's multiple co-tenants that sign the lease at the same time, the landlord should make out the security deposit return as it's stated in the lease. So the landlord should have a policy in the lease that says it will be returned to one tenant or both tenants. And furthermore, when the tenancy is ending, the landlord should be using an itemized a security deposit disposition agreement. Again, a security deposit disposition agreement that specifies who will be receiving the security deposit, whether it's going to be mailed, delivered in person, and whether it's going to be issued jointly to all parties or issued solely to one. So that's for the landlord and the tenants generally to work out amongst themselves, although the landlord should generally just issue it to one person, because when you have roommates coming in and out, co-tenants, that's for them to decide who is going to get their security deposit reimbursed and transferred. So the landlord doesn't have to accept, partial security deposit return and then partial issuance to a new one. So.
All right, well, that's going to wrap things up. I just want to say a couple quick things. First, thank you so much to Nick for your time today. I know you were having to do this from outside your office, so I also appreciate everyone's patience with any technical problems we had. There is going to be a survey link you'll see when you leave. We'd appreciate if you would take that. And then one last plug for the law library. If you're looking for any samples of agreements like some of the ones that Nick showed you today, if you're looking to find answers to questions on topics we didn't cover today, we have a lot of landlord-tenant information here, and we can help you find legal forms. So come by and see us or give us a call at 619-531-3900, and we might be able to help you out. Thank you, everybody.